So I mentioned earlier that part of what we're doing here is I am doing this sort of deep dive, that we are trying to get an understanding of each of these individual pieces. So before I go too much further into the offer itself, I want us to think about why it is that we're even doing that deep dive. And really, ultimately, you're going to be tasked with solving problems about contracts. The kind of problems in the profession that you will be solving are either, how do I make sure that the agreement my client wants is the agreement that they actually get and can enforce? Or, my client has come to me with this particular problem or set of circumstances, and I need to work out, firstly, whether there's a contract, secondly, whether it says what my client thinks it says, and thirdly, whether or not they've got some cause of action either against them or for them. Now again, thinking back to this, we're going to spend a lot of time over this course, the first 7 weeks, talking about circumstances in which a contract may or may not exist. In the real world, that's almost a given every time. When you think about it, the reason these cases even get to court is because at least one person doesn't want to stand up to obligations that they may or may not have. They either think, this isn't fair, somebody's saying I've got an obligation and I never intended to have an obligation, or most of the time, actually I don't want to pay that amount of money or do that thing, so I'm going to say, well, there was no contract in the first place. So it's actually kind of legal logic right from the very beginning. So part of what we are doing here is actually working out how to unpick the first part of that question. Is there a contract at all? Because if there's no contract, then I'm pretty sure that my client can't sue someone else or can't be sued by someone else. Secondly, it's only once we know that there is a contract that we can then work out, well, what does the contract say? What is the actual promise that was made? So again, in the real world, you'll start with a presumption often that there is a contract. It's only when one party says, hang on a minute, there is no contract here, that these issues will actually even come into play. So the vast bulk of the cases that you'll come across are the sorts that we'll deal with much more in advanced contract law. And that's why that bit of the textbook keeps being updated and my bit stays very much the same most of the time. Not entirely, but mostly. So in order to determine whether a contract exists or not, we need to identify each of these elements. And so we start with this idea of agreement, which really comes down to the question of whether there is consensus. But we're going to start unpicking that in the traditional way by understanding what an offer is, so we can identify whether an offer has actually been made. Consideration, for the time being, we're going to talk about that as price, as I've mentioned a couple of times, but really consideration goes to the question about exchange and whether or not the parties have struck a bargain. Intention goes to whether or not the intention of the parties is that the agreement will be legally enforceable, that they can sue on it or be sued if they don't keep their promise. And lastly, certainty, the one I infamously forgot, which really goes to the question of whether or not the details have been identified properly. So we need to think about what we need to do to create a contract and why we need to know whether there is a contract over and over again. So the contract itself is really encapsulates the rights and the obligations that the parties have. Talked a little bit earlier on about Iraq. I'm not planning to really go into that in any more detail other than to say, really, Iraq goes to working out what the issues are, harder to balance this than I thought it would be, which actually requires you to understand what the rules are. Because some of the rules will go to what the issue is. So one of those questions we just had in the quiz was, which of these kinds of conduct would be an invitation to treat? You actually need to understand why it's important to distinguish an invitation to treat from some other form of conduct in order to be able to think through that issue. So sometimes the issues arise out of the facts, sometimes the issues arise out of the rules. So let's actually get into offer properly. I actually need you to think about this as agreement. So we're going to concentrate on offer, but at the same time recognise that understanding what an offer is helps us understand what an agreement is. And not all circumstances will lend themselves to allowing us to identify offer plus acceptance equals agreement. Sometimes we will be able to find the consensus in another way. So most of what we're doing today in this topic is working out, firstly, is there an offer? Working out what the tests are, the objective tests are for identifying whether an offer exists. To do that, we're going to talk about the kinds of things that count as an offer. We're going to distinguish them from other kinds of conduct that may not be offers or may be. We're going to talk about what the bilateral, unilateral distinction is, and we're going to hopefully get to the point where we can work out when would an offer be revoked. So assuming that we have actually got an offer that is not one of those other distinguishing kind of conduct and it hasn't been revoked, then the next question, which is what we're going to be spending Monday doing, is has it in fact been accepted? And has that acceptance, what kind of conduct constitutes acceptance? When do we distinguish acceptance from other things? Has it in fact been communicated? How can it be communicated? What does the law, what do the rules say about that? And then what happens if they don't correspond? What if there is a difference that acceptance itself tries to vary the contract in some way or the offer in some way? So, but working out those pieces, it is important to remember that the nature of agreement itself requires some kind of consensus. So the language we use is consensus ad idem. So agreement between each other, amongst ourselves is kind of the translation, a meeting of the minds. So when we started talking about earlier, where do contract laws come from, why do we have them, this does go to this kind of moral idea that people should keep their promises. And in determining whether an agreement is reached, it's important to remember that the test is objective. So what do I mean here by an objective test? You would have heard that a lot or read the word a lot in the reading. I've just put it as a kind of sideways statement in that earlier slide, objective test. What am I talking about with an objective test? What do I mean? Someone down the back here. Sorry, what's your name? Hi, Stacey.
So an objective test is basically looking at what a reasonable person would do as opposed to what the action is.
So Stacey says an objective test is one where we work out what a reasonable person would do. So effectively in terms of offer, and that's absolutely right, essentially it doesn't matter whether you thought you were making an offer or not, whether you meant to make an offer or you meant it to be something else. What matters is what a reasonable person, having the same information and experience as the person who claims an offer was made, would have or should have thought as a consequence of your behaviour and your actions. Similarly, it doesn't matter whether you knew or believed there was an offer or didn't believe there was an offer. If a person objectively in your circumstances would have believed an offer had been made, having all the information that you have, then an offer has been made. It is an objective test. And the words actually come from Carhill, secret mental reservations are ignored. So the fact that you secretly thought, I don't want to do a deal with this person, it doesn't matter. You actually have to say or do something that makes it very clear. So in a nutshell, offer plus acceptance equals agreement. Pretty easy, right? So offer, here I'm talking about a clear and unambiguous statement that is capable of acceptance on its terms. So the offer itself has to be pregnant with the other things: intention, certainty as to the subject matter, clarity around what the consideration will be. It needs to be matched with an acceptance. That acceptance needs to be also clear and unambiguous acceptance of the offer without any variation. And that acceptance needs to be communicated to the person who made the offer. And those things, so offer plus acceptance equals agreement, and that's the formula. So why on earth are we going to go through this for 2 weeks if it's that simple? Because when we drill down, nothing is really simple, and it can be difficult to identify offers in the wild. So, an offer is an indication by one person. Let's get this language right. The offeror, I think I need to point at this one in order to not go all over the place. So that language is really important. Offeror and offeree. Little side note, how unlike me to side note into something else. Lawyers often use those suffixes or and e. Or means the person who is giving or doing something, and the e means the person who is receiving or transacting. So a really classic one, and this often differentiates those with legal training from those who don't, are mortgagor and mortgagee. So the language, common language we use is, I'm getting a mortgage from the bank. I'm going to buy a house and get a mortgage from the bank. In fact, legally, what happens is you buy a house and you give the bank a mortgage. A mortgage is a form of security that means that if you don't pay the loan that you've applied to buying the house, if you don't pay it on time, then the bank, who is the mortgagee, has the right to do things that might include foreclosing on the mortgage, selling your house from underneath you. So often in layman's terms, we'll say things like, the bank owns my house, or I got a mortgage from the bank. Actually, you've given a mortgage to the bank. So you are the mortgagor and the bank is the mortgagee. So when we're talking about offer, we use offer, offeror makes the offer. And so offeree, somebody want to hazard a description of who an offeree is or what an offeree is? Might not be a person, might be a company.
The person who accepts the offer.
Person who accepts the offer.
The person who's offered the offer.
The person to whom an offer is made. The person who, is offered the offer. A person who is within the class of people or legal personalities that can accept the offer. Now we use acceptor as the person who actually accepts the offer. Because once we've got offer and acceptance, so an offer is made to an offeree, the offeree accepts the offer. Actually, acceptor you don't even really need to use, because at that point everybody's a party, right? We've got a contract, so they're parties to the contract. So an offer is the indication by an offeror to an offeree. So that's important because it might not be the whole of the world, it might just be one person, of their willingness to enter into a contract with that person, the person to whom the offer is made, on particular terms. So the offer needs to be pregnant with what the terms are. An offer itself can't give rise to a contract. It creates in the offeree a particular power. So at the point in time that an offer is made and hasn't been withdrawn, think about it commercially, all of the power is with the offeree. Because a contract will be made if they accept, or not made if they don't. In fact, absolutely not made if they reject it. So, in determining whether an offer has been made, we use an objective test. Carlisle and carbolic smoke ball, we'll talk about that in a second. What the offeror actually thinks is completely irrelevant. going a little bit more modern in our cases here, Toll and Alpha Farm, which is one we'll spend a bit of time on a bit later in the semester, has a really good section in there about the objective test and the extent to which the intention of the other side, the person receiving these communications, is irrelevant. Important to know that offers are made to offerees. An offeree is effectively going to be a class of person, but it might be an individual. I could make an individual offer to you. Sorry, what's your name?
Brandon.
Frank?
Brandon.
Brandon, sorry. That's how I'll get your names eventually. So I could make an offer to Brandon. I could make an offer to anybody in the first 3 rows of this class. I could make an offer to only students who are participating online. I could make an offer to any RMIT student. And none of those would be an offer to the world at large. But you can see there is a class of person, or in the case of an offer to just a Brandon, an individual who could accept. So if I make an offer to Brandon, and I asked your name just 10 minutes ago and it's out of my head already. Lauren? No. Gabby. Lauren is there. There we go. I will get there. So I could make an offer to Brandon, and Gabby could say, I'd like a bit of that, thank you. I'll do that. If Brandon doesn't want to take you up on that, I'll take you up on that. And I can say no. I have just made this offer to Brandon, and he is the only person. Hi, sorry. Feel free to yell out if you want to interrupt me, because I don't wear these glasses as a fashion statement and I can't really see. Call out. Sorry, what's your name first?
Imogen.
Hi, Imogen.
Is that curtailed by anti-discrimination legislation?
Is that curtailed by anti-discrimination legislation? It will depend. That's a lawyer's favourite expression. It depends. If I am making a, well, to start off with, what would probably, say I've decided to offer Brandon $100 to go through and clean up that course document, the course notes, and I only want him to do it. Based on nothing other than he is of a race and gender and sexual persuasion that I am prepared to contract with, and I'm otherwise not prepared to contract with other people. Firstly, there are probably rules in my own employment contract with RMIT that say that I should not favour one student over others. Sorry, Brandon, it was so good between us for so long, at least the last 15 seconds. So that number. Secondly, if I was making that choice because of race, gender, sexual orientation, gender identification, anything else, chances are that if that was my main thing, that there would be a legislative overlay. But if I am, oh, that's going to be really annoying. If I am making commercial contracts where it's not an offer to the general world. So if, let me explain. So if I, for example, sold coffee in a shop that's easily accessible by anybody, but I refuse to serve women, and I'm in Australia, clearly, that would be problematic because I'm making an offer to the world and excluding on one basis. If I sell legal services and decide that I'm only going to sell services to other law firms, but I'm not otherwise distinguishing, I can make commercial decisions that limit who my offer is. If I've only got one thing to sell, it might be, say I'm selling my farm and I decide I'm only going to sell it to one of my children. It really wouldn't matter because I've only got one thing to sell, and there might be other reasons for doing that. But yet, we can get caught up in where legislation throws over the top, but that's a really good example of areas where the legislation is saying, well, or the legislature is saying, the common law just thinks about contracts as private laws and assumes that everybody has equal bargaining power. But we, as a government or as a policy statement, recognise that there are certain groups within the community who don't have equal bargaining power, and unless they're able to negotiate, if they're excluded from negotiation altogether, then they will never be able to participate in this part of the economy, so we will throw that overlay over. Then you can decide whether it's a good or a bad thing. So I have my views, but I try well to hide them. Okay, so next thing here, let's keep going. This is terrible language, but this is possibly the best overview definition of what an offer is that I have ever come across. And embarrassingly, given what I said earlier about taking care with American resources, it's an American resource. An offer is the manifestation of a willingness to enter into a bargain, so made as to justify another person in understanding that his assent to that bargain is invited and will conclude it. It's very gender laden as well. So an offer is the manifestation of an intention to enter into a legally enforceable arrangement made in such a way that the person to whom it is made understands that by accepting it, that there will be legal consequences. They will have enforceable obligations and enforceable rights.